Ready, start. The said delay has been explained, taking the ground that the appellants were bona fide pursuing their LPH before the division bench of the High Court, and once they realized that the LPH are not maintainable and they have been dismissed as not maintainable, they decided to challenge the judgment and orders passed by the learned single judge before the Supreme Court. In view of the above explanation, though technically pursuing the LPH and the time spent thereon may not be a very good cause to condone the delay, but since there is no willful or deliberate delay or any default on part of the appellants in assailing the judgment and orders of the single judge dated 26/6/2006, rather they were all thoroughly vigilant of their rights, we have ignored the delay and have heard the parties on merits, more particularly on the correctness of the judgment and orders of the single judge. Mr. Ranjit Kumar, learned senior counsel for the appellants, argued that the information/complaint submitted by C. Ram Saini and by Vijay Kumar Agrawal does not make out a cognizable offence for enabling the court to direct for the registration of the FIR. The High Court could not have directed for the registration of the FIR as the procedure laid down by the various decisions of this court was not followed before approaching the High Court. Secondly, the High Court could not have recorded a finding of commission of a cognizable offence, which leaves nothing for the investigating officer to opine on after the completion of the investigation except to submit a charge sheet. He further argued that in the so-called preliminary inquiry conducted by the Joint Director CBI, it has been reported that no cognizable offence is made out for the purpose of investigation. Therefore, it was not open for the High Court to have substituted its own finding and to direct for the registration of the FIR. He emphasized that even if for the sake of argument it is accepted that a case for investigation is made out against Binod Kumar Pandey, there is no averment or iota of material to rope in Neeraj Kumar, the other officer. A further submission has been made by Mr. Ranjit Kumar, learned senior counsel for the appellants, that the High Court manifestly erred in directing the investigation to be conducted by the special cell of the Delhi Police, which ordinarily investigates the matters relating to terrorism. The High Court also committed an error in directing the exclusion of preliminary inquiry report dated 26/4/2005 of the Joint Director CBI from consideration during the investigation. Mr. S. V. Raju, the learned Additional Solicitor General for the respondents, pressed an application for the impleadment of the CBI, contending that as the preliminary inquiry was conducted by an officer of the CBI and the case involves allegations against the officers of the CBI, therefore the CBI is a proper party so as to defend the inquiry report and its officers.